us today. For the Hansard record, would you please state your full name and the capacity in which you appear today?
My name's Narrelle Clark and I'm the President of the Australian chapter of the Internet Society.
Would you like to make a brief opening statement before we go to questions?
Yes, I would. So the Internet Society of Australia, ISOC-AU, welcomes this opportunity to provide comments to the inquiry into the Telecommunications Interception and Access Act. ISOC-AU's interest is that of ensuring and promoting the development of an open and sustainable internet for the benefit of all people. As such, our interest and membership spans users, developers, service providers and researchers in personal, commercial and not-for-profit contexts. Remarks will therefore be restricted to that affecting internet services only and not the broader telephony services context, except where its regulation affects internet services. The Internet Society of Australia is the Australian chapter of the Worldwide Internet Society, the organisation which homes the internet standards body, the Internet Engineering Task Force, and participates actively around the world in many internet governance and policy discussions. Our expertise is in providing neutral, technically informed advice across many jurisdictions. By way of introduction to me, as the President of the Australian chapter, I'm also a member of the Internet Society's Global Board of Trustees. I have tertiary qualifications in physics, engineering and management, including a master's degree in engineering, specialising in telecommunications, as well as 20 years' experience designing, building and managing telecom and internet networks. My current day job is with the Australian Communications Consumer Action Network, but I must make it clear that I'm not speaking on their behalf, but purely on behalf of the Internet Society of Australia. ISOC-AU believes that the principles which apply in the physical world should continue to apply in the online world and applauds the Australian Government's support of the application of the United Nations Declaration of Human Rights to the Internet. ISOC-AU therefore submits that any legislative change should adopt a technology-neutral, principles-based approach that would better withstand technological change and couple that with preservation of fundamental citizen rights. At least any changes to the legislation should avoid, wherever possible, being unduly technology-specific, as that obviously leads to endless amounts of specification that would need to be adjusted on a continuing basis. ISOC-AU also notes the broader context within which this inquiry is taking place. There is no doubt that Australia has some repairs to undertake on its international reputation as a result of recent revelations of extreme internet surveillance. As we speak, an international forum on internet governance has been convened in Brazil, at which there will be calls for something akin to a declaration of rights for the internet, or even an internet Magna Carta. Now, whether Australia joins such calls or signs on to any such document is yet to be seen. However, there is a clear sentiment from users within Australia that there should be much greater clarity over surveillance and far better online privacy protection. It is of major concern to us that increases in surveillance by state actors and non-state actors have a corresponding decrease in trust by users of the internet, which is a vital and essential infrastructure for modern society. Over recent times also, much discussion has taken place on the concept of access to so-called metadata, with assertions that metadata does not include the content of communication. We contend that without appropriate technological standards defined by an independent standards body, this claim is inherently untrue. The existing mechanisms for gaining information about the material that transits across a telecommunications, or rather internet network, for example by using the web page addresses visited by a user, inherently contain specific addresses for many, many elements within the page, even third-party elements in turn requested by the page, such as advertising. Thus, the amount revealed about an individual, their family, workmates and broader community is potentially very large. In many cases also, this data is dynamic and changes from moment to moment, and often today even depends on the types of other sites visited by users with the advent of cookie correlation, none of which is under any control by the individual users. This is further complicated by the emergence of apps, where users have extremely little knowledge of the types of communications that are going on in the background, the level of security, their pervasiveness, and the types of actions that these apps undertake in the background. We further note that the European Court of Justice recently ruled against the retention of metadata and said, quote, by requiring the retention of those data and by allowing the competent national authorities to access those data, the directive interferes in a particularly serious manner with the fundamental rights to respect for private life and to the protection of personal data," unquote. The court was particularly concerned that, I'll go on, "it does not require any relationship between the data whose retention is provided for and a threat to public security, and in particular it is not restricted to a retention in relation to one, data pertaining to a particular time period and or particular geographic zone, and or to a circular of particular persons likely to be involved in any one way or other in a serious crime." And it goes on and further clarifies that its deep concerns with that type of approach. The Joint Committee on Intelligence and Security's recent inquiry revealed that an astonishing number of parties have been granted access to metadata with extremely little oversight, no guarantees over destruction of the material after its acquisition, and certainly no right for redress by consumers when it is misused or exposed. We contend that this is an extremely disturbing situation, as the potential for damage by misuse of this data is extremely high. I've also gone on to, in another context, try to assess the sheer volume of data that would be required, given the fact that we have, over 500 gigabits of 500 gigabits per second capacity of our international links. Now, if only 10% of that 500 gigabits per second is metadata, then you have the capacity to produce terabytes of data within hours if that type of material is then collected, sampled and stored. There are attendant costs for the carriage and storage of that and management of that sort of data. The capacity for that type of material to become honeypots for other attackers is extremely high and requires the greatest amount of security in management of that type of system. That same inquiry also contained a request for an offence to be created where a person refused to provide encryption keys. We contend also that this is an impractical offence due to the fact that in many cases an encryption key is automatically and dynamically generated by software for the purposes only of that transmission and destroyed after use. And that sort of key is often completely unknown to the user concerned. With that type of offence, the user would therefore then have no defence that they didn't know the key in the first place and may then be liable for something that they can't possibly hand over. We note that there are a number of shortcomings within the TIAA at present, the Telecommunications Interception and Access Act. We submit that the overall controls and reporting arrangements for lawful interception have in general been strong. However, there is concern that the penalties for lapses in appropriate governance and controls over access to interception mechanisms have not been enforced. Furthermore, there should be clarity over which act applies where competing legislation exists. That clarity does not seem to exist today. The ISOC-AU supports the Australian Law Reform Commission's recommendations with respect to the destruction of materials gathered under an interception warrant. We call for an increase in clarification over warrants. The existing provisions do not make it clear as to which specific services are required under a warrant. There should be no level of interpretation required by service providers as to which services they need to require when a warrant is presented. We also have concerns about the practicalities of attribute-based interception. That is another approach that has been flown recently. And we contend that this will lead to extremely complex systems needing to be installed and managed again by telecommunications and internet service providers. And these systems will require ad hoc coding and scripting in order to extract out the types of data that may well be requested at any given point in time. Again, these systems will need to be managed these very complex systems will need to be managed very carefully, very closely, with the highest level of security. And we are deeply concerned that this level of security does not exist in practice today. Now, with respect to the retention of metadata, without appropriate technology standards, metadata should not be retained beyond strict business need. Where metadata is retained, there needs to be the strictest standards around retention and access, and I can't reinforce that enough. Should access to metadata be granted, considerably higher standards of access and oversight of these processes need to be implemented, including penalties for the breaches of these sorts of standards. Specifically, we call, as was mentioned under the JCIS recommendations, that there be no retention of browsing history. The existing provisions do not make it clear as to which agencies have the right to gain access to metadata. Should metadata be defined, then there must be clear understanding of which agencies are eligible to access communications information, and the proportionality of suspected crime must also be correspondingly high. We support the establishment of a public interest monitor, and we would be happy to assist in that type of activity. And any further imposts on service providers which result in greater costs will ultimately be borne by consumers themselves. It is essential that these costs be taken into account and avoided wherever possible. So in closing, I refer you to a recent statement on surveillance issued by the Swedish Foreign Minister Carl Bildt, where he proposed a series of 7 principles be observed. Now, rather than take up too much of your time now, I won't go through those specific principles, but they're very sound and I encourage you to take them up. Thank you.
Thank you. Very much appreciated. Senator Selgino. Senator Marshall.
Thanks, Ms Clark. You said that, and as I understand it, and I'm nowhere near as expert on this as you, that on my devices there's apps or programs happening in the background already monitoring what I search, what I look for, where I am, what I do, how often I do it. So they're all corporate entities, I suspect, wanting to find out how they can market things to me and what my interests are and all that. So I'm already being spied on and surveilled by people more people than I probably even guess. I've got no idea how many people are doing that or how many organisations are doing it, but they are doing it. I think you referred to that in your presentation. And I don't have any protection from that. Why ought then I be so concerned about someone also finding out where I am and where I go? Because they're doing that in a form anyway, often, surely, including browsing history, which, and I'm sure someone's keeping it if they think it's useful to them commercially. They're keeping my browsing history and looking at that and probably sharing it with others as well.
Indeed.
Yeah.
And I suspect as a politician, you might well be a greater object of interest than than I might be.
But then why should I also be concerned about law enforcement agencies utilising some of that information and probably only a fraction of the information that commercial interests are already using?
We would contend that both parties need careful examination and oversight.
Sure.
Now, and also the Australian Federal Police and ASIO and other entities such as that seem to have very strong controls over what they do to a large extent. But when they go beyond that and start to create significant stores of this type of data, then it becomes very, very attractive to people that would use it for nefarious purposes.
What sort of purposes?
One thing that we've seen a lot of has been cyber stalking. So, for example, the evil ex-partner. That seems to be one of the most common types. This type of use for domestic violence purposes.
But if you were good enough to get in and trawl through stored material, well, you'd be good enough to do the sorts of nefarious deeds on the computer anyway, wouldn't you? Because I'm just trying to work out what I should be scared about. We're going to store all this information, and you say, well, then that's a problem because it's stored and people can access it. But why should I be worried about that? What's the mischief there for me?
Well, while it's very convenient for us to be sold the right pair of trousers at the right time. If you take that to its extreme, then the types of impact that people can have where they are stalking or harassing people are extreme, and that this type of activity can go on using facilities that are created by telecommunications service providers at the request of government agencies seems to be more than just a little ironic.
All right. In terms of engineer by profession in this area, so there is the capacity to create the storage of all the information generated for, say, 2 to 5 years. Is it physically and technically possible to do it?
Well, it would appear to be so. Gmail manages to store vast arrays of people's email, but the cost of doing that for our agencies, I would suggest, is extremely high.
Can you give a ballpark figure for? Is it in
I've
the
not
tens
done-
of millions, or is it in the hundreds of millions or billions?
Well, I would suggest that collectively it would at least be of tens of millions, potentially of hundreds of millions, and that was the type of figure that was suggested, that was put forward by IINet in their JCIS inquiry. I've not done a specific analysis to do a costing of this, and I would be happy to do so if you want to resource that.
No, well, we're also broke. Well, in terms of, some witnesses have put to us that, the service providers make their money out of this business, and, criminals utilise that service to make their own ends, and the service providers then should bear some of the responsibility of setting up the data retention costs to enable us to, catch the crooks that are using their system. So the cost ought to be borne by the providers, the service providers, not by anyone else.
I don't think I'm in a position to really... But I would suggest that that type of money might be better spent on securing the networks themselves.
Right.
To make them more robust, to put more resources into best practice activities, to make sure that we have the most effectively operating telecommunications and internet networks that we possibly can, that are secure and robust and able to withstand things like the generalised denial of service attacks that occur on a daily basis.
All right. Okay, thank you.
Okay. I'm interested to draw you out on, you made some remarks on the way through about metadata, or the distinction between content and non-content data. We'll put these questions to IINet or others in the tech community when we get to them, but do you want to just firstly just flesh out for us your point of view on the distinction between, as it's often put, and I think it was yesterday once or twice, the envelope and the letter? Do you think that's still a useful metaphor for us to base the law upon?
At this point in time, as I said, there are no clear technical specifications for metadata in the internet protocol world. In classical telephony, there are call detail records, which are defined under International Telecommunications Union standards. It's very clear. I'm about to launch into acronyms here, the E164 number, so that the telephone number of the calling party, the A party calls the B party at such and such a time for such and such a duration, and these are associated with addresses, physical addresses. It's clear, it's simple, it's available. In the internet world, that type of description doesn't exist for the myriad of types of communications and communication services that we have. So while it might seem simple enough that if I were to send an email address, if I were to send an email from my, president at isocau.org.au email to Senator Scott Ludlam's email, that might be a simple envelope over which we could time and date stamp. When my email program sends that, it then interacts with any number of servers along the way until it reaches its final destination, which would be your email server and ultimately your email program on your device reading it. At each intermediate point, data is effectively generated through the logging capacity of each of the transitory equipment. In order to get metadata, you need to turn logging on onto each of those different pieces of equipment, not just your email. Well, your email client won't typically have that, but the email servers along the way, the routers, the other types of caches and storage equipment along the way. If you turn logging on, logging was designed for fault finding. It wasn't designed for collecting a tiny piece of information or just, reading the outside envelope of an address. Logging was designed to discover why things were going astray, why a server isn't working properly. And so the sort of data that you produce out of that is extremely verbose. There is all sorts of detail about connections that were attempted and made or not made, and so forth. And so in order to collect that type of small amount of envelope type data, you need to gather a lot more information in the first place. Again, without standards that say only collect this and only collect that, only store this and only retain that, then each piece of equipment or software program that's installed on the different pieces of equipment do things differently.
I think I remember seeing somewhere publication of the metadata surrounding a tweet, and the tweet is 140 characters long, and the metadata is a page and a half.
Exactly.
Of other stuff.
Yes.
Relating to who you are and where you are. In your time dealing with these issues and with these questions of surveillance and personal privacy, do you see a particular direction in play? Is the trend towards greater surveillance, or is the trend towards greater privacy? Some of what the law enforcement colleagues were telling us yesterday sounds very much like an arms race, if anything. And I'm just wondering what you think the general tendency is in technology, because sometimes we hear about a balance between security and privacy as though we just weigh them up and find a sweet spot in the middle.
I would agree that it does seem to be an arms race. Recently at IETF meetings, the Internet Engineering Task Force meetings, significant calls were made for an increase in the level of encryption built into every single one of the protocols that we examine. And I'm seeing that is indeed happening, that all of the security provisions in any of the internet protocols are now being re-looked at and with a view towards implementing greater levels of encryption all the way along.
Okay, so bad guys are going to encrypt everything.
Well, and good guys.
And good guys. And activists and whistleblowers and journalists and anybody at all who doesn't feel like being arbitrarily surveilled. At the same time as this blanket of data retention is going to be passed over the entire population. So it's really only ordinary folk who aren't going to be encrypting their traffic.
Or as somebody else has pointed out, you're only one dyslexic terrorist away from an unwanted connection.
Right, okay. Not a happy example. Senator Xenophon, do you want to take up the call?
Yes, thank you, Chair. Thank you for your evidence. And if this was asked when I was out of the room, I apologise, but at the moment there are many agencies that have the right to metadata collection, including the Victorian Taxi Inspectorate, the RSPCA, various local councils, because of the revenue raising aspects of it. Presumably it's meant there to track down people that haven't paid their council rates or fines or whatever. What is the level of metadata that they can obtain in addition to phone records? If you're looking at email records, it doesn't actually. Does it show the subject? What's your understanding of the metadata? It shows the subject material.
If you open a typical email program such as Microsoft Outlook or Gmail or so forth, that you can look at the headers of a message, and that will list every server that email traversed on the way through. Not just definitely the subject, the to address, the from address, the time it went, the time at which it was received by all the intermediate servers. Some unique identifying strings for each of those messages as well, any of which can be faked because these are all stored in plain text typically. But that's another issue again.
So metadata, when people hear about metadata, they don't realise how you can triangulate and actually get a lot more information.
Indeed, they don't realise that at all.
And when Senator Ludlam said, I think that is it the fact that the metadata with Twitter, despite the fact that it's just 140 characters, can actually, the metadata would include all that 1.5 pages of information that Senator Ludlam referred to.
Yes, that's true.
And that would include the people that you've tweeted or where you're from and...
Carries your IP address, apart from...
It will carry your IP address, but I can't give... That would depend on specifically the type of application that you used to do the tweet or receive the tweet. So the Twitter client on my Android phone, for example, will behave in a different way to the Twitter client on somebody else's iPhone or someone else's laptop. It all depends.
Right.
And I would have to go through each application and examine that data accordingly, because again, there is no specific standard for that type of service.
The particular interest I have is in respect to whistleblowers that may want to contact a journalist or a member of parliament, and the use of metadata surveillance of those without a warrant, without having any sort of judicial oversight. Is it your view that that there ought to be different rules that apply? Do you have a policy view in terms of should different views, rules or different safeguards apply where you have whistleblowers that want to contact a journalist or a member of parliament about maladministration or malfeasance within government or the private sector? Do you have any views in relation to that? And I suppose another way of putting the question is that do you consider that anyone who contacts an MP or a journalist with a whistleblower, that they're quite exposed with metadata surveillance in terms of their identities being tracked down?
I would agree, yes, that in many cases those people will be highly exposed and without them realising that they are exposed to that.
Because it provides the IP address, and that means you can locate their names, or let's say they...
Where you can correlate the IP address with that specific endpoint device, yes.
But how would you then be able to identify the person? You'd know through the purchase of it, or...?
Well, that depends on the way the IP address is allocated and the way records are retained about the IP address. So in fixed line communications such as DSL, fibre to the home, cable and so forth, they will retain, typically ISPs will retain records of who got what IP address at what particular time for how long. In the GSM network, so the mobile device space, there will be similar records retained, but they will also be tied usually with an IMEI, so a unique identifier for that particular handset. In the IPv6 world, which is the next generation of the internet protocol, I love talking about these things with politicians, sorry. In the IPv6 world, there is a construct whereby you can take the MAC address, which is a hardware address, a more unique identifier, not entirely unique identifier, but a strongly unique, if that's such a term, that address can be tied with the IP address in order to create the IP address concerned that is then used for communication. So what I'm saying is that there are degrees of identifiability, and where you can tie that with other databases, then you can become more and more specific.
So does that mean...
Confusing.
Yeah, no, so does that mean that if a whistleblower, even if they're using an anonymous...
An anonymiser.
A non-deployable whatever,
yes,
they can be easily tracked unless they've gone to the trouble of going to an internet cafe.
The IP address will be tagged in with that email communication, typically. Yes.
So any whistleblower that contacts a journalist or member of parliament with metadata, they can be tracked down. That information can be used to track down who they are, effectively. Is that right?
Yes, they can.
Okay. So the only way a whistleblower can be assured of anonymity would be to go to an internet cafe and use a device that's not their own.
Well, they'd need to take steps such as that in order to obscure their communications, yes.
Because you can track them down via the device.
Yes.
Okay, that's rather depressing. But so that's why, and in terms of but you need the cooperation of an ISP to get that information, don't you?
You need either their cooperation or you need their security to be poor. But even with good security, there are always holes in that security.
So even if an ISP has no knowledge of it, that it can be hacked quite easily.
Well, I wouldn't say necessarily quite easily, but in some cases, yes, it can be very easy.
Okay. So if you want to speak to a whistleblower, it needs to be in a park somewhere. With
I'll park at 4 o'clock in the morning.
I think
Silence and control. You'll be right.
Okay.
Order.
All right.
You good?
Thank you for depressing me.
All right, let's depress you a bit more. So we've been talking a little bit about the creation of a large national database that would have records for every person who has any kind of telecommunications footprint at all in the country. It's a 2-year minimum mandatory data retention.
so. Not only the 23 million citizens that we have, but anybody who happens to be visiting, wandering through,
Yep.
or communicating with us in some way, shape, or form.
Okay, very, very, very large data sets on everybody. Established yesterday that there's no threshold of extra protection for a 10-year-old kid or a High Court judge. The law would apply evenly. And it would be up to the telcos to host and protect and keep this data under wraps at unknown cost. For what appeared to me to be entirely legitimate reasons, like the purposes that the agencies are after this is to go after the mafia and terrorism and serious stuff. But can you just spell out for us what the collateral risks are of creating those data sets in the first place?
Well, the collateral risks are that these huge profiles can be set up on anybody at all, and that data can be linked in ways that are not what I would think of as legitimate. That it can be, if I was looking at a web page, there could be other applications and so forth running in the background that might be prefetching data that I had absolutely no interest in whatsoever, that might have nothing to do with me, but yet is there on that page.
Yeah.
I beg your pardon?
It's then attached to your name.
Which is then attached to my name, or my children's name, or my vague associate's name, but then it's treated back to me. So the level of invasiveness of all of this is significant, and it is all without necessarily any control over the cause or reason behind it. When do I stop being a citizen and when do I start being a suspect? Is it before I've even thought about the crime or after I've done it? And that's the type of concern that we have.
So just to be clear, the concern is if this information is retained in the form that is, that there'll be a profile built based on every citizen
or even visitor.
Well, is that physically possible, and why? Like the purpose is for crime prevention or tracking down criminals. That's the purpose. That's the stated purpose.
Indeed, that's the stated purpose. But
Yes.
once that database exists, then it can be put to any other number of purposes by any other number of people.
No, it can't.
I contend that the level of security that needs to be in place for you to be able to prevent such a thing is extremely high.
All right, so there's a difference of your saying that someone could break into the system and do all that if they wanted to create 23 million profiles, as opposed to the organisations that are storing the material doing that deliberately as a matter of course. Or is that what you're suggesting, that will happen as a matter of course?
Okay, so there's two cases here. There is the the nefarious purpose put by some stranger, but there is also the attractiveness to the organisations themselves to mine that data and create new marketing approaches, or to sell that data on to.
But they're doing that now.
other
We know
people.
they're doing that now. We had that discussion.
Well, they are doing that to a certain extent now, and we would suggest to you that needs to be tightened.
Yeah.
That a greater degree of privacy needs to be imposed on these players.
Yeah.
They're doing it with much smaller data sets that are fragmentary.
Sure.
And you consent to those.
But we
when you
can
tick
tighten
the
those
box.
things up, but we can tighten, you know, we're going to have the same controls and rules on stored data, I assume. I don't think it's there.
Well, none
yet
of
as
this
the
is spelled
proposal.
out as yet.
No.
No, we haven't identified. Well, I mean, that's part of the job of this committee, I suspect.
But surely, you know, we've got to concede that it's a useful tool for our law enforcement agencies to track
Most
down
certainly.
people that are committing serious crimes.
Most certainly, and we would like to see the law enforcement agencies continue to track down people who commit serious crimes.
That's right.
Absolutely, we would.
But they would find it useful if you had to carry a webcam with you that broadcast everywhere you went. That would also be useful. At some point, there has to be a threshold of usefulness. Otherwise, we'll just install a camera in every room of every house in the country. That would also be useful. It would be very useful in fighting crime.
Well, no one's suggesting that.
It's where we're heading.
Well,
Sorry.
I'm sorry. Well, I absolutely fundamentally disagree that that's where we're heading. I don't see that at all.
If usefulness is the only test, there's no limit at all on what could be installed. That's all. We have to apply some other tests, I suspect.
Well, then we don't look for any information. If that's the other extreme, isn't it? We do nothing. We allow criminals to run free. We make no investigations. We don't try to track them down at all. I don't see, you know, using absolute totalitarian extremes as a justification for not doing something that is useful and practical, and I think is necessary now.
Well, let's see if it is.
Well, we would suggest that 2 years or 5 years is certainly far too long to retain this type of data, and that there needs to be a significant, well, I think there needs to be a lot more discussion about how long that length of time should be, whether it be, you know, the length of time that a typical disk takes to churn through a piece of data. At this stage, I'm not prepared to contend any specific length of time. And I think that a lot more effort needs to
But you're not
be put
opposed
in.
to the storing of data. You're simply saying there needs to be more discussion about the length of time it can be stored. Is
The
that
length
fair?
of time, the specific types of data,
Sure.
this whole concept of attributes-based systems, there needs to be clear technology standards for this. Certain things need to be built into the equipment and the applications so that we can do this in a clear and consistent manner with appropriate levels of control. None of that, I believe, is in evidence at this point in time.
Any other questions?
No. Fine.
All right. Is there anything else? Otherwise, we might let you go. Thank you very, very much for coming in this afternoon.